depends on filing with Your Honor in camera. You know, the records of the disciplinary actions, you know, against any of the officers that I mentioned. Here we are, November 23rd, 6 days into this case, and I have yet to receive crucial, you know, impeachment records. And I'm being told that, you know, they will present it to Your Honor and leave it to Your Honor whether I get it or not. Well, Your Honor, these are things that the government should have been, you know, thoroughly prepared for so that we don't have this event, you know, arising during the trial. And my main point here, Your Honor, is that the government should have known everything regarding Ms. Metran. Because Ms. Metran's role is really, really small. All she did was she arranged to have with her friends, you know, the 4, I guess, Air Force reservists, to meet with them at, we call that Applebee's. She was leaving, I believe, in a few days for basic training. And then they left there around almost 9 o'clock and went to the venue, and she stayed with them until 9. Rather, they arrived there at 9 and left at around 11:20. The government knows this because there's a video recording of her leaving. Exactly what time she left, and as she said, she called her boyfriend to pick her up. So the government should have known everything about this Metra. And the government yesterday should have been prepared if they had watched the videos that we all watched. They should have known that, you know, maybe Ms. Metran said was not complete in her, you know, recounting what she engaged in and what she saw while she was at the venue for around 2 hours and 15 minutes. And now the government wants to bring her on. And there's no one to blame, Your Honor, but the government. We had time yesterday if the government would have just been prepared. And so I recite all these things to show you that this is how the government, you know, does its trial. It is not prepared. And so now, with me being prepared and taking advantage of the government's, you know, unpreparedness, you know, the government now wants to take back its mistake and, you know, undo my strategy. There is just no reason for the government to be allowed to recall Ms. Metran. That train has left. And I believe that the government needs, you know, to suffer the consequences of its, you know, unpreparedness in its, you know, questioning of Ms. Metran. So I believe, Your Honor, that the court should deny the government's motion.
If I may respond, Your Honor.
Thank you. Commissioner Olan, please.
Thank you. Well, that was a lot, Your Honor. I'm not exactly sure where to start. Frankly, there was a lot of noise there and issues raised that were non-material to the government's request. I'll address that briefly first, and then I'll address what's really relevant here. The first issue as to the government's preparedness. As the court is well aware, oftentimes the government reintroduces witnesses shortly before trial to witnesses who have already been interviewed either by GPD or the Attorney General's office in order to establish what the witnesses remember, and so that everything is fresh in everyone's minds. It's not unusual at all. A number of these follow-up meetings or calls that Mr. Lujan referenced were in regards to requests that he made from us. And there were a number of requests that Mr. Lujan also didn't raise until the start of trial. One of them he already mentioned, the fact that he requested the GPD records, disciplinary records of the officers at issue. Now, the records that Mr. Lujan is requesting, the proper way to have requested that information was by filing a pretrial motion with the court, and then us filing those records under seal with the court for review, for in-camera review. We are currently in the process of gathering that information, and that information will be forthcoming very shortly before any of the officers whom we requested the disciplinary records for will be testifying. So he'll have that in advance. Mr. Lujan also asked, he raised an issue about one of the videos from the venue that cut off, and he only brought that issue to our attention during the trial. He's had this video for months and months and months and months, and yet he's only now raising that issue with us. So we, of course, had to do some follow-up with some individuals, including Mr. Roberto, on that specific issue. So to cast blame on the government as if we're wholly unprepared and we wait until the trial to do everything is really an unfair characterization. The fact of the matter is, I guess this is the point where I do fall on my sword and acknowledge the fact that yes, I did commit a rookie mistake by not following up with Ms. Matron yesterday on the specific statements that she made, which we have concrete evidence or proof that she was, again, either mistaken or flat out lying. Now, that said, the relevant issue, the issue that's really relevant here and material, is the fact that the government has the right to recall witnesses during rebuttal. And in this particular case, we want to save Ms. Metron the unfortunate situation of having to be subpoenaed and missing her trip. We don't want to have her miss her trip. Maybe, I'm sure that Mr. Lujan doesn't want to have her miss her trip, and certainly I don't want to either, which is why we're making this request now, Your Honor, so that we can just do what we otherwise would be able to do without inconveniencing the witness any further. And again, there really is no prejudice here, Your Honor. The fact of the matter is that even though defense counsel didn't cross-examine the witness yesterday, he can still cross-examine her after we follow up on those few specific matters that I referenced, Your Honor. Yesterday, just like yesterday, where defense counsel wouldn't have known what to necessarily cross-examine the witness about before having heard her testimony, once again today, it's no different than today, the statements that she makes, which actually defense counsel should be well aware of what the government is referencing, he has just as much preparation today as he had yesterday in order to cross-examine the witness. So there really is no prejudice here at all, Your Honor. Again, I apologize to the court for committing, what I do acknowledge is a rookie mistake, but I do urge the court to grant the government's request to allow Ms. Matron to testify, so recall her so we can get her back on the stand, follow up on a few statements that she made, and then let her get on her way, go on her trip, so she doesn't have to miss her training or whatever her obligations and responsibilities are. I hate to have to tell her that the reason why she can't is because Mr. Lujan objects to the government's request. Thank you, Your Honor. Appreciate your consideration.
Now, may I just real quickly? Regarding the disciplinary records, the entire file was given to the EG's office, as I understand it. And so, since April of last year, the government had those records. They are impeachment records, some of them. Any disciplinary action against the any of those officers that I mentioned, and I understand there is some, would be impeached.
Well, you know, Mr. Lujan, I just a quick question though. What? Because usually, you know, it's brought up at a pretrial motion to ask for this information. Okay, you say it's impeachment. Okay, there's disciplinary records that are impeachment, but they don't necessarily. Well, you don't know they are impeachment until you make the motion to have them produced, and then have the government submit it to the court to review to see whether or not the information contained therein is impeachment or has some value as impeachment or is irrelevant to, you know, the
But
reasons
Your Honor,
that
I
were
did
covered.
make the motion. I made a motion for discovery
When was this?
last year. The first thing I ever do in a case is file a motion for discovery.
Okay, and you specifically requested the disciplinary records for?
I don't recall, I didn't know any, I requested for any records, for, you know, impeachment records. And so a disciplinary record would be impeachment. So that should have been given to me. That the fact that they have it is, you know, I've been told they have it and that they're turning it in today.
Has there ever been, like, Guam Supreme Court case that said disciplinary, internal affairs, disciplinary records
I don't
automatically equate to
I don't
impeachment?
know that, Your Honor, but apparently they do think it is because they're giving it to you.
Oh, sure, because that's something that is so private, right? I mean,
Yes.
non-disclosable, like, if the disciplinary complaint didn't go anywhere, what you've disclosed that someone got a disciplinary complaint.
But I've been told by them that one of the officers got it.
Well, we'll entertain that when you get produced, or when they bring in the disciplinary reports, okay, and then the court will look at
In
that.
fact, I've been told they were giving it to you today,
But today,
this morning.
sure, I didn't see anything.
I was told
Okay,
because
yes.
I've been asking, where is my record?
Yes. But let's go back, because I just wanted to mention that, okay? It's the court has an obligation under the statute or the